Looks like everyone's ready. It's my understanding we have Mr. Taylor and then as well as Mr. White who will be arguing. Okay, thank you. Mr. Taylor, you may begin.
May it please the court, I represent Gordon Garrison, the plaintiff in this case. Mr. Garrison brought this action alleging nuisance, trespass, and violation of Iowa drainage law. With regard to the nuisance claim, the district court held a pretrial hearing pursuant to this court's guidance in the Hanna-Michael case to determine if the three factors set forth in the Gaki case applied here in determining the constitutionality of the immunity statutes 657.11 and 657.11a. The district court correctly found that two of those factors, the fact that Mr. Garrison had lived on his property for a number of years and had put substantial improvements into the property, and that he suffered significant hardship. But the court erred in finding that Mr. Garrison received a benefit that made the immunity statutes constitutional as applied.
Do you have to be sued and invoke the immunity yourself in order to be deemed to have benefited from the immunity statute? Or is it enough that you had your own confined animal feeding operation, sheep in his case?
That the immunity statute is a defense, and so it doesn't come into play until the animal feeding operation is actually sued or some sort of a claim is made.
What if one of those neighbors, though, wanted to sue him, went to go see a lawyer, a good lawyer who knows Gaki and reads it and says, but you know what, they're probably immune. You might spend a lot of an attorney's fees. So isn't it possible that case has prevented anybody from taking that next step because they think that he has immunity? Kind of like an invisible protection?
I'm not sure how invisible it is, but I think that the point here is that the benefit that the Gaki was talking about, and I'd like to make the point too that the benefit in Gaki was part and parcel of the analysis of whether the statute was oppressive or not. And the Gaki court, I think, balanced the significant hardship from a nuisance.
Except it said there was no benefit. And ordinarily, I mean, immunity statutes, love them or hate them, they're designed to protect a party from incurring attorney's fees. I mean, it's not simply designed to provide a defense on the merits, but it's designed, the immunity statutes, there's language in some of our case law talking about kind of deterring claims. So you had a CAFO on your property that was within the scope of that could have availed itself of immunity. And so it's not really true that there's no benefit. There's some benefit. And I mean, you say it's theoretical, but is it enough to have a CAFO on your property, and if you are sued, you could avail yourself of the immunity protections of statute? I think you understand where I'm generally fishing. I'm being verbose.
First of all, you use the term CAFO, which those of us who do this kind of litigation has a definite meaning. It means a large animal feeding operation, 1,000 head or 1,000 animal units or more. Mr. Garrison's sheep operation was much less than that, and it wasn't, the big confinement operation that we think of.
So?
Well, the statute, I agree, says animal feeding operation. But the second part of the answer to your question is that Gaki didn't say no benefit, it said no comparable benefit or no a corollary benefit, something like that. I forget the exact wording, but it indicated that in order for the statute to be a constitutional as applied, the benefit to the plaintiff had to be commensurate with the harm. And that's why I think...
I mean, I'm going to pile on a little bit too. Here's where I have trouble with the argument. It seems to me that the premise of Borman and Gaki and that line of cases is that you know, that there's sort of that there are property rights at issue here, and when you give a confinement immunity, you are in essence taking property from one landowner and giving it to another landowner. So when you have this sort of transfer of property rights, it's hard to say that that is effectuated just by having a statute, which is what those cases have said. It's hard to say that your client didn't receive a benefit because it got a little bit of that transfer of property rights too. It was able to have under the statute some immunity from engaging in activities that might otherwise be a nuisance under Iowa law, right?
I guess, Your Honor, in Gaki and in Hanna-Michael as well, although Hanna-Michael didn't discuss the benefit a part of it very much, if just having a small sheep raising operation, I hate to even call it an operation, it wasn't even that much, or being a partial owner, as Mr. Garrison was, in land that's being used to apply manure.
A big benefit in Gaki. We said benefit that doesn't inure to the public generally. And your client got that, right?
But Gaki said no a commensurate benefit or no comparable benefit. And to me, that indicates that the benefit, in order to make the statute constitutional, has to be something that rises to the level of at least equaling or overcoming the harm that's being done. The essence of Gaki was that the statute was oppressive because it allowed the CAFO to harm the plaintiff with no commensurate benefit to the plaintiff. The Gaki court focused on the Gabbert versus Nebegal case, which I think, you know, although there are a lot of distinctions, obviously, between the facts of those two situations, the point of the Nebegal case was that the neighbor who didn't have the livestock was still getting a benefit, a current significant benefit from that fence because the livestock was being kept from coming on his property. Whereas in this case, Mr. Garrison is suffering the nuisance from the CAFO, but has really gotten no benefit from that immunity statute and never would.
It's kind of an as-applied type situation. In other words, if we're dealing with this theory of property rights from Borman and Gaki, that there's only a benefit if you're operating the property in a way that it creates a nuisance and the statute applies. And if you're not doing that, then there's really no easement, is the way Borman put it, that you're availing yourself of, right? I mean, isn't that what you're saying, that your client was operating a feeding operation, but it wasn't a nuisance that got...
Right, exactly, yeah.
Can you address a different issue, which is kind of the error preservation issue with respect to the Borman, more takings type analysis?
And that is a bit confusing, I admit, of the way it came out. We addressed the takings issue in our motion regarding the constitutionality of the statutes. The district court just focused on the as-applied a part of that. Then in the ruling on the summary judgment motion, the district court just denied all claims, even though the takings claim was certainly presented. So I think two things here. The district court, in ruling on the constitutionality of the statute, by not addressing the takings clause, in essence, said that the takings clause was still there, and Borman was satisfied. And
Here's the way I see the record, which is maybe a little different, but tell me where I'm wrong. It looks like initially what you argued was that you argued the Gaki factors, and that under the Gaki factors that the defendant was not entitled, the defendants were not entitled to the immunity. And you didn't argue, hey, by the way, under Borman, we don't even have to worry about the Gaki factors. You know, you didn't raise that until it got to the 1.904 motion, which may have been too late. Am I missing something there?
we did address the takings issue in our motion to have the constitutionality of the statute considered, but of course, the only fact finding the court had to make was regarding the as-applied portion. And then when the a decision...
Borman, there was really, if Borman, you know, under the Borman case, there's really nothing to litigate. I mean, they don't get an immunity from a loss in property value claim. But it seems to me you never raised that point until you got to the 1.904 motion. Am I wrong?
With all due respect, yes, we did raise it in our motion. And so the court, by not ruling against us on that, ruled in our favor on that.
Let's say that we disagree with your Gaki claim. What would be sent back, or what would be left in this case to sort out?
The exceptions in the immunity statute. That's what the district court ruled on in terms of the summary judgment motion. And we had evidence that we believe at least got us past a summary judgment on that.
The odor claim, the change in value, the diminution in value under the statute would still be left, is what your claim is?
The real estate value, yes. Yeah. So if the case is sent back, we would ask the court to make a finding that the summary judgment's not appropriate because we have put forth enough factual evidence to get past the summary judgment on all of the factors involved.
Is your trespass claim subject to the Gaki unconstitutionality analysis, or is it separate from the odor nuisance claim?
We specifically based a nuisance claim on odor and the trespass claim on the water pollution.
Takings claim, it seems like the district court also said that you didn't have any evidence of the diminution, the actual damages. Does that prevent summary judgment on the takings claim, and how does that affect your trespass claim?
The damages that we alleged regarding the trespass was the enjoyment of the property, because Mr. Garrison spent considerable time and effort and money creating an environmentally a protective area there in his property, and that was part of the use and enjoyment of his property, and that was damaged by the of the trespass of the water pollution.
Okay, and so that goes right to the trespass claim, which is kind of separate. Then on the Borman takings claim, does the fact that you were not able to present an expert to value the diminution of your value, does that affect the summary judgment?
We did present an expert in the, what I would call the Gaki hearing. His name was Brent Taylor, no relation, and he did testify. And the defendants had no expert evidence at all on the taking.
It did devalue it, but he just wasn't able to come up with a number?
He had an estimate, but he couldn't do a formal appraisal because there were no comparables.
But he did have an estimate of the valuation?
As I recall, yeah. Or at least a range anyway.
Clarify a procedural issue for me. So the hearing that was held was the Gaki hearing, correct?
We had the hearing, yes.
Was it the right time even to kind of litigate or present these other issues? I mean, I guess I'm kind of not understanding what happened during the hearing. If the court was holding the hearing for the particular purpose of dealing with these Gaki issues, it seems like the other summary judgment items, there shouldn't have been an expectation that there was going to be evidence put on for a hearing that wasn't being held for that purpose. What happened there?
Understanding your question correctly, the summary judgment was just based on the record in the file, not the evidence that was presented at the Gaki hearing. If I'm answering your question, yeah.
You were you were trying to strike the defense, right?
The immunity defense, yes, yeah.
Would have covered the Borman ground, correct? If you had raised it.
We did raise it, and I think by inference it was addressed, yes. And we've cited the Eggeman case in our briefs that this court has held that if an issue was raised and the court obviously had to address that in order to reach its decision, that the record has been preserved.
Chief, I'd like to ask just one more question that we haven't covered. Obviously, there's federal litigation involved here. And as you know, there was ruling and some findings in the federal litigation. The suggestion is made by your opposing party that some of those findings are preclusive, including findings related to the trespass claim. Explain to me why they're not preclusive.
Well, the standards for issue preclusion were not met because the federal court was looking at different issues. It was based on a different.
But true enough. I mean, different theories. Got it. But the finding of fact was rather specific about the pollution, was it not?
Well, the finding of fact was based on what the federal court was looking at, which was whether or not there was a current or ongoing pollution. And at that point, the defendants had stopped applying manure to the field uphill from Mr. Garrison's property. And it was, it was under the RCRA and the Clean Water Act, which was a totally different set of issues. And with all due respect to the federal court, I don't think that the federal judge had to or should have done all that fact-finding on a summary judgment.
Okay, thank you.
Thank you, Madam Chief Justice, Honorable Justice of the Supreme Court, and may it please the court. My name is James White, and I'm honored to appear before you today on behalf of the defendants, New Fashion Pork and BWT Holdings. This case is about one animal feeding operator suing another with no evidence that the defendants were violating Iowa law or otherwise failing to prudently manage their operation. And now, while defendants won this case on summary judgment after the court applied Gaki, this case is a great illustration as to why Gaki was wrongly decided and should be overturned.
But the interesting issue, I find it interesting issue at least, as to whether there was a benefit provided. And there are maybe two schools of thought on it. You've heard them here today, or maybe there's more than two, but I've heard two. One school of thought is, well, you get a benefit of the statute if your activity amounted to a nuisance but is protected by the statute. And the other school of thought is, no, you don't limit it there. If the statute applies generally to animal raising, you get the benefit of the statute really in all cases. So if you have 500 animals on your property, you're getting a benefit of some kind because you're deterring possible suits. So I did notice that nobody had any case law on either point, and you can correct me if you're wrong about that, about what constitutes a benefit, and maybe because it's a fairly unusual kind of factual setting. But tell us why we shouldn't require some degree of concrete protection. Justice McDonald was at least asking the question. You heard it, I think. So you understand my general interest. Please give us your best answer.
We would obviously go with the latter interpretation of the benefit prong. And to comment on your point, I raised it the other day when we were practicing for this, that there really isn't anything that explains the benefit prong of Gaki in my review of the case law. And so that's why those cases were not cited. But if we were to apply it as the plaintiff wishes, if we were to apply the benefit prong that way, this case perfectly illustrates why that would be unworkable, because the plaintiff ended his animal feeding operation before he filed suit, and that would have prevented defendants from actually getting evidence of what was going on at the site at the time the animal feeding operation was underway for 40 years, from the 70s or 80s until 2018. Further, it would require, if we go with plaintiff's interpretation, it would require us to litigate whether the plaintiff's operation was a nuisance full-fledged at the same time that we're talking about whether defendants had a nuisance. So we believe that would be unworkable. And workable.
I mean, we have claims and counterclaims and lawsuits all the time. It seems to me that kind of an easy issue to regulate as a district court judge.
Be unworkable. It's a pretrial issue that the Gaki factors were addressed here at a pretrial stage. If the defendants were trying to prove that plaintiff's operation in this case was a nuisance, they would have been robbed of 40 years of evidence that would have lent itself to a finding of that. So that's why we believe it would be unworkable. And we believe the benefit is that the statute protects, it protected the plaintiff in this case for 40 years, or for the years since the statute was enacted, forward to 2018. It protected him from any nuisance suit because it was, as the court stated earlier, an invisible shield that served to deter plaintiffs from filing a lawsuit. And further, it served its purpose, to the stated purpose of stopping.
In light of the case law piercing the statute? I mean, is that true? Did he have immunity just because of the statute? We know that nuisance suits are allowed to go forward despite the statute. Why shouldn't there be some sort of showing that there was an actual claim or threatened nuisance here?
Situations in which the statute is found unconstitutional as applied. However, as written, and as the legislature has decided, there is immunity if the CAFO operator complies with the law and
Cited And when?
5, I believe.
25 years of at least that kind of nuisance suit available. Is there any evidence that his animal feeding operation was subject to a nuisance suit during that time?
Evidence that the operation was subject to a nuisance suit or that neighbors complained or anything like that. I think
Drivers who pay for liability insurance get a benefit even if they're not in an accident or not sued.
a great analogy, Justice Waterman. And yes, there's certainly a benefit even though you don't have to use what has been given to you.
Borman takings claim, is that before us? Was that preserved?
The Borman takings claim was raised for the first time in a motion to reconsider. The motion to reconsider was not ruled upon until after the notice of appeal was filed, actually 48 minutes after the notice of appeal was filed. I believe it's the Freer versus DAC case that addresses that. It's a 2019 case.
Like if you file a notice of appeal with a pending 1.904 motion, you've essentially waived the 1.904 motion. Is that?
That it was never raised at all until the 1.904 motion, or it's just that the district court was not allowed to rule on it because the notice of appeal was filed first?
That it was never raised.
In the written motion?
Raised whatsoever. If you look at the briefs that were before the district court, there is no mention of a takings claim as applied to Mr. Garrison. There is a citation, a lengthy citation to Gaki or Hanamichael that in turn discusses the takings claim, but there's no argument that anything constitutes a taking. And we believe that that was a strategic choice. We believe that the plaintiff didn't want the district court to be able to split the baby, so to speak, and to award or to say, we're going to keep your diminution damages alive, but you're not getting the special damages, which was an option that would have been before the court had they raised the takings claim.
Client wins even under Gaki. Why should we overrule Gaki?
Because, Your Honor, there are 3 reasons. First, Gaki runs counter to the express purpose of 657.11. Second, this case, which is the latest example, is in a long line of cases that proves Gaki is unworkable. And third, Gaki is inconsistent with subsequent case law under the Inalienable Rights Clause. And so the express purpose of 657.11 is to prevent CAFO operators from incurring the costs to defend nuisance suits. In this case, we got to the eve of trial. There's no evidence of negligence. There's no evidence of violation of Iowa law, and it still took to basically the eve of trial. I think it was 2 weeks before trial before the defendants got the benefit of the nuisance immunity. It's just clearly unworkable. And to my understanding, we are the first defendant to ever win on a pretrial challenge under Gaki. And it just, 20 years of history, or 18 years of history, proves that Gaki has been unworkable and it runs counter to the statute.
Gaki, what happens to Borman?
Takings analysis is not affected, in our opinion. The takings analysis is separate. Gaki is with regard to special damages, and so the Borman line of cases will still stand, and we are not challenging the takings analysis because that issue was not preserved. It was never raised.
This claim just a little bit, and you heard me open it up a bit with asking about the federal court's ruling. 2 things. You heard counsel's response saying that, well, the federal court ruling only related to ongoing current pollution, A. B, what's your view of the federal court ruling? And B, what entitles you to summary judgment on the question of what I'll just call increase under the trespass theory? I think you understand my questions.
And so under the trespass claim, there was really 3 key points. First is the water test, second is the experts, and third is damages. So the water tests are what the federal court addressed. And the federal court said plaintiff's water tests cannot be tied to damage to the property. They don't show an increase in nitrates. There's no expert to interpret them, and therefore they're meaningless.
Comparing apples to oranges there, because in the federal court, they were only looking at water tests starting in 2016 after your client had started its operation. And in this case, the trespass claim is based on comparing nitrates before your client was even there until 20, whatever.
So, Your Honor, I believe before the federal court was that chart, that Excel spreadsheet from 2001 to 2013 where Mr. Garrison had listed the nitrate values. Importantly, missing in all the evidence is nitrate levels from 14 or 15, and then there are the tests, the actual water tests from 16 on. And so I believe the previous tests were before the federal court as well. But what's important before the federal court and the district court here is there is nobody to tie any significance, to put any weight to those water tests, to say that defendants were the cause of any increase in nitrates, and we would also submit that the nitrates did not increase. And
The two actual findings of the 2016 and 2018, or the 2018 finding related to the frozen manure spreading on the frozen ground.
So that was one consent order that arose out of some pretty strange circumstances where the DNR allowed us a waiver, allowed us to.
Right, so is that not evidence that there was a trespass from your property of manure onto Mr. Garrison's?
Regardless of whether that's evidence or not, we would go to the fact that there are no damages. Plaintiff.
Trespass, can't you get nominal damages for trespass?
We believe that they would have to show damage to the property for trespass, and they could not do it.
For that related to a trespass case?
We cited a case in our brief on damages both in the drainage law and the trespass context, that the proper measure of damages is damage to the property or diminution in value. But
If I walk on my neighbor's property and don't cause damage, I'm subject to trespass, nominal damages probably. But the problem with nominal damages is it might give rise to a punitive damage claim, maybe.
the plaintiff, for whatever reason, chose to stay far away from the 2018 administrative consent order. That was a choice that they made, a choice that we were surprised by, but they didn't argue before the district court that, well, this 2018 administrative consent order and frozen ground application was the cause of our damage. They never made that argument. So we would say it wasn't before the district court, it wasn't preserved, and it wasn't really part of the summary judgment decision. We would, but
To a prior issue, unless you want to talk more about this preclusion, but when you were asked about overruling Gaki, you said there was 3 parts to it. In the third part, you said that it's inconsistent with the inalienable rights clause or subsequent developments in that area. Could you go back to that point?
Yes, Your Honor. We filed a notice of additional authorities. It was filed March 15th, and we cited the Jacosma case, the Gray case, and the Planned Parenthood case. And all 3 of those cases appear to apply a rational basis review to a challenge under the inalienable rights clause. And we also point to the special concurrence in Hanna-Michael, where Justice Waterman and Justice Mansfield recognized that Jacosma applied a rational basis review, and that should be the test applicable to 65711 going forward. And so those are the authorities that we have to address that question, Your Honor.
Can't reach the constitutionality of the damage caps in 65711A if we affirm the summary judgment?
We would submit that issue, the 65711A damage limitations, would be moot if this court affirms the district court on summary judgment.
So how does the rational basis analysis play out in this case, and why does that militate in favor of overruling Gaki?
Your Honor, the court has addressed this on facial challenges to 657.11, and that this is a valid exercise of the police power, that 657.11 is a valid exercise of the police power, and that promoting animal agriculture is a legitimate government purpose that would satisfy rational basis review. And defending or decreasing or avoiding costs in the nuisance suits is a legitimate purpose, as the statute states.
But in Gaki, that was only the first step. Gaki itself says that it's a legitimate purpose, but that the statute was too oppressive, and that under Article 1, Section 1, you're entitled to enjoyment of property interests, and that the statute oppressively ousted, really, property interests. So the mere fact that police power might be supported doesn't knock it home, it seems to me.
We would disagree, and we would submit that the correct analysis under the Inalienable Rights Clause is rational basis review, as the concurrence in Hanna-Michael recognized. And I see my time is up. Thank you all for your time. We ask that you overrule Gaki and affirm the other rulings of the district court. Thank you.
And Mr. Taylor.
Well, let me tackle overruling of Gaki first. The Gaki, you have to understand, first of all, was not created out of whole cloth. The Gaki court cited to prior cases.
No, it was based on the Inalienable Rights Clause, which really hadn't been the source of any kind of successful claims in recent history. Let me read the clause. All men and women are by nature free and equal and have certain inalienable rights, among that which are those of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety and happiness. Now, if we start saying that this is a source of rights that you can go into court and enforce, aren't we going to have claims by people who say that I'm not happy and I have a right to obtain happiness that the state of Iowa is depriving me of? You're smiling, but I mean, that's in there, right?
But Gaki, of course, wasn't based on that particular provision of that a constitutional right, but it could be something you would have to determine and define what happiness is, if you can do that.
If we have a long history of allowing nuisance suits against animal operators, would that make a difference in our analysis? So, I mean, you can trace nuisance suits against pig breeders and operators back to the early 1600s. I mean, this is not something new, like a claim to sue for happiness. Does that make a difference in our Article 1, Section 1 jurisprudence?
I'm not sure it does. But as I say, Gaki was not based on that, so that's certainly not any reason to overrule Gaki, I don't think. And contrary to what Mr. White said, I don't think those cases that he cited or other cases since Gaki have caused Gaki to be under question or have in any way reduced the impact of Gaki.
Would you dispute that Article 1, Section 1 requires a rational basis test?
I think it does. Now, in Gaki, they didn't use those magic words, rational basis, but they said, we applied the following highly deferential standard of review. That seems to me sort of a rational basis statement.
Couldn't tell what the test applied in Gaki actually was.
Magic words, but I think that's in essence what they were doing. And as I said, they relied on prior cases, so it wasn't something they just came up with out of the blue.
But under Article 1, Section 1, that all cases of rational basis is akin to equal protection. There could be some cases that are rational basis and some that involve fundamental rights that have a stricter scrutiny.
Yeah, yeah. But in terms of Gaki, I think it probably was a rational basis, although, as I say, they didn't use those magic words. But, in Jacobsma, in Delarma versus Access Energy, in other cases, Gaki has been referred to, cited with approval. So there's been absolutely a long line, both before and after Gaki, that supports the Gaki decision, and there's no reason to violate stare decisis here, because there's been nothing since Hannah Michael in terms of a change in the law. There's been no criticism or weakening of Gaki, other than the special concurrence in Hannah Michael. So it seems that for this court now to just, I don't want to say arbitrarily, but just without any change or any finding that there's something that just makes the Gaki totally.
Counsel, what about our sort of wrestling with the benefit issue here, right? I mean, I don't think really anyone has been able to sort out what exactly that, benefit element means. And does that sort of indicate that maybe Gaki isn't workable, and that perhaps, the test there should be tossed out?
Perhaps this case is the vehicle to define what that benefit is. And that's why we argue that that benefit has to be something that's commensurate or comparable with the harm in order for the benefit to make that statute constitutional as applied. I see my time is up, unless you have other questions.
Garrison versus New Fashion Pork is hereby submitted as well, and court is adjourned for the morning.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.